Slip and fall lawsuits and a timeline of events. What you should expect during your slip and fall case. If you are thinking of filing a slip and fall lawsuit, you may be unsure as to how long the case may last. The length of the lawsuit may depend on the circumstances surrounding your case, what the defendant has to say, and much more. Here is where we hope we can help. We hope to shed a bit of light onto the world of a slip and fall case so you understand what goes on behind the scenes, and what happens, and when. The complaint. Your personal injury lawyer will prepare a document that details your claim. Every state requires a different amount of detail in the complaint, and some may need a short summary, whereas other states may ask for a detailed summary. Regardless of what state you live in, the complaint is likely to mention who was involved, a description of the fall, how the fall took place, who is considered, alleged, to be responsible, what the allegedly responsible party needs to pay, whether the allegedly responsible party needs to pay for their inaction or action. Your complaint will need to be filed in the court where your lawsuit will be brought. Your complaint will also need to be served with the summons on the party, individual, business, or governmental entity that you'll be suing. The summons will tell, or order, the defendant to file a response to your complaint within a specific amount of time, which is usually 20 days. When the defendant answers, the answer to your complaint will be given in the form of a document. This document will include the defendant's response, and it will either include an admittance or a denial of the allegations that have been made in your complaint. Depending on your case, the defendant may state that the complaint does not contain enough information for them to deny or admit the allegation. The answer will also show affirmative defenses which could help the defendant to prove that they are not completely liable, or that they are not liable at all. The answer usually needs to be given in 20 days, but in some cases, the defendant may gain an extra 20 days if they agree to waive some specific legal defenses. The discovery phase. During the discovery phase, both the defendant and the plaintiff, the injured party, learns a lot about the slip and fall case. This is done by the defendant or the plaintiff asking the other party to produce specific documents or evidence, and it can also involve interrogation. Interrogatories are questions that will be answered under oath and in writing. This part of the claim can take some time. In some cases it can take years if the case is very complex, but in other cases, it may take a matter of months. The length of time can also be affected by the court's schedule and the plaintiff's medical treatment. Filing motions. Before the trial begins, motions will be filed with the court in a bid to resolve issues that arise. These motions are typically known as pre-trial motions. The most common types of pre-trial motions include the motion to compel. This involves either the defendant or the plaintiff asking the court to order the other party to do something that they may not agree to unless the court asks them to. This type of motion is usually filed when one party refuses to produce specific documents or to give evidence. The motion to dismiss. This usually involves the defendant filing this motion quite early on, as they may consider the lawsuit to be likely to fail. A motion in limine. This motion involves requesting to keep specific evidence out of the lawsuit. This can occur if the defendant does not wish the jury to know that they have liability insurance that could cover much or most of the claim. If the jury were made aware of the insurance, they may feel more inclined to ask the court to award the plaintiff more money. This means that the evidence is prejudicial, and could be used regardless of what happened during the slip and fall, and what it was caused by. A motion for summary judgment. This is a hugely powerful motion, and if it is granted, it can ultimately be game over for the trial. Motions such as this are usually filed when either the defendant or the plaintiff believes there are not enough supporting facts for the other party's claims. Resolving a lawsuit without a trial. On occasion, either party may be tempted to resolve a lawsuit without it going to trial. One method for doing this is known as a mediation, and the other is a settlement conference. Both of these methods are quite similar, but they can help to resolve a dispute. The difference is that both the defendant and the plaintiff typically arrange their own mediation with the help of a private mediator. However, when it comes to a settlement conference, it is the court that usually conducts it. Both types of settlement can take place close to the end of the discovery phase. If there isn't very much to dispute, and the defendant and plaintiff need to find a middle ground, these methods can be used. The middle ground in many slip and fall cases refers to the amount of money that the plaintiff is likely to receive. Going to trial. Once the discovery phase has been closed, the slip and fall case will be set on or appear on a trial docket, which is a list of cases that will be heard in court. The court will hear each case in order as it appears on the docket. Typically, slip and fall cases can take 2 to 5 days to resolve, although they can take longer if they are quite complex. Collecting judgment. If your slip and fall lawsuit wins, you will have to collect on your judgment. This means that you will have to wait for the defendant to pay the monies that have been awarded. A defendant who has lost a case will have from 30 to 60 days to pay a judgment. However, if the defendant does not make any payment during that time, your personal injury lawyer can force the collection of your award. While the above procedures and order of procedures may reflect what typically happens during a slip and fall lawsuit, every case is different. Speak to a personal injury lawyer as soon as you can so you can file a slip and fall lawsuit without delay.